Hello, good afternoon, everybody, and welcome to the BMA Law webinar. Just to introduce myself, my name is Philip Jones. I'm a partner in a law firm in South Wales, and I've been practicing in litigation and dispute resolution for something in the region of 30 years. One of my specializations is partnership disputes with a particular relevance to the medical profession. And today I'm going to be talking to you about some of the problems that can be encountered and some of the issues which arise when partnerships come to an end or when partners are leaving a partnership either voluntarily or by compulsion. Now, this is the second in a series of webinars, and I did an earlier webinar this year in which I spoke about the importance of partnership agreements. Now, insofar as expulsion and retirement are concerned, it is very important that you do have a partnership agreement, because if you do not have a partnership agreement, then considerations such as voluntary retirement, compulsory retirement, and expulsion fall away, because there are only very simple routes without a partnership agreement to remove or to end the partnership, which normally gives rise to a dissolution, which can have quite some serious legal consequences for you. But today I'm going to talk on the presumption or the assumption that we do have a partnership agreement in place. I'll take you through some of the terminologies that apply, some of the important considerations and some of the issues that you see in a fairly standard partnership agreement, the process that has to be followed, and I will touch on some other issues which do often arise in contentious issues with expulsion or compulsory retirement, and in particular those which relate to any type of discrimination. Now, the first thing really is to look at the terminology. Now, retirement, of course, is something everybody thinks they want to do at some point in their life and to retire, but it has a rather stricter definition and meaning in a partnership. When you form a partnership, you enter into a legally binding relationship with other people under which you effectively put mutual trust and confidence in them. You agree to enter into that partnership for a period of time, and if you wish to leave that partnership, you have to either dissolve that partnership if you don't have a partnership agreement, or alternatively, when you're preparing your partnership agreement, you need to give some consideration as to how you would wish to exit that partnership agreement or the partnership. If you don't have that, then often it can end up in court or by what we call a dissolution of a partnership at will. The two terminologies that I will concentrate on today are retirement in its strict sense and how it relates to partnerships, and expulsion. Dealing with the first of these two, the first one is retirement, and that splits broadly into two categories, what we call a voluntary retirement and what we call a compulsory retirement. Now, a voluntary retirement is exactly what it says on the tin. If you've been in a partnership and you feel like you would wish to retire, and the provisions of the agreement allow you to do so, then you can leave voluntarily. What you do need to keep in mind, however, of course, is the terms of that retirement, and to make sure that the partnership agreement allows the partnership to continue, and that the impact of that retirement is not too significant in relation to the partnership. For example, periods of notice that have to be given, and I'll comment on that in a bit more detail later. You may also, however, have a provision which allows for a compulsory retirement. Now, a compulsory retirement is exactly as it says, what it says. It is when a number of the partners, often a specified majority, are able to use the provisions of the partnership agreement to require somebody to leave. Now, that may sound very similar to an expulsion, but there's one or two key differences. Insofar as a compulsory retirement is concerned, normally it would be a fairly straightforward matter to compulsory retirement because you do not have to give any particular reasons. Now, some of you may or may not have heard of green socks clauses. Now, this is a clause which is becoming increasingly popular in partnership agreements, and what it effectively allows a number of the partners to do, a majority, is to remove a partner without any particular reason being given, and only if they consider it's in the best interest of the partnership to remove that person. It's a difficult decision to remove anybody from a partnership, and normally with an expulsion you would have to give reasons, but the benefit of the compulsory retirement is that you don't have to put an allegation, deal with that allegation. You simply have to put forward the vote, and if that vote is carried and the decision is made, then the retirement should follow. In both compulsory and voluntary, you need to give careful consideration in your partnership agreement as to what will happen after the partner retires, and you need to give some thought to whether or not you wish to have provisions for garden leave, whether or not you wish to deal with clauses which prevent what is commonly referred to as the last man standing. And the last man standing is where gradually one of a number of partners retires, the numbers dwindle, and then it becomes one person left with the responsibility of dealing with the affairs of the partnership. So you need to give some consideration when you're looking at your partnership agreement that it is actually fit for purpose, that it allows partners to voluntarily retire, and if you wish, it can allow you to have a provision under which, if there are issues and you wish to remove somebody without reason, you can do so. We then move on to expulsion. Expulsion is a very different beast. It sounds more serious than a retirement, and it is where some act or some failure of one of the partners is so serious that it goes to the root of being in a partnership with that person. Normally, expulsion provisions will provide a number of specified breaches of the agreement which can give rise to an expulsion. The difference between the expulsion and, as I said, the compulsory retirement is that if you want to expel somebody, you have to establish the grounds, and the less objective those grounds are, the more generalized or opinion they could be, the more difficult sometimes it can be to expel. There are some obvious ones. For example, if somebody is no longer on the performers list or has had difficulties or suspended by the GMC or indeed struck off, which can result and can be easily proved. But where there is another provision which says that the other partners consider there's been a breach or a serious breach of the agreement, you have to establish the breach has taken place. You have to establish that it wasn't too long ago, and you have to look very carefully at putting your evidence together to support the allegation of breach, which in turn would support the expulsion vote if that vote is passed. So in a nutshell, those are the ways in which you can leave the partnership, normally via a partnership agreement, voluntarily, either a compulsory retirement without reason, or an expulsion where reasons have to be provided. Now, once you run into difficulties, or if simply a partner wishes to retire, which route do you follow? And which route is the best to proceed by? Now, often this will depend on whether or not there are contentious issues which have arisen between the partners. If it's a voluntary departure, then the partner who wishes to retire can simply follow the route of the partnership agreement. If that doesn't work, or there are reasons why that partner wishes to leave sooner or later, then anything can be agreed. And normally, most sensible partnerships will have an arrangement or will have an ability to resolve any difficulties caused by the strict application of the partnership provisions on voluntary retirement. The default position is that if you wish to leave, follow the partnership agreement, give your notices, at which point you will leave the partnership, or the expiry of those notices, you will leave the partnership. Where it becomes more difficult, however, is where there is a difficulty which has arisen between one particular partner. Now, there can be any number of reasons why issues arise. There can be deadlocks, there can be differences over the direction of the partnership, there can be concerns over performance, both clinically and in relation to other administrative tasks. And there can be very, very difficult disputes which arise, and it becomes very difficult then to try and operate the partnership with one partner who the other partners believe is underperforming, or is materially breaching the partnership agreement. Now, the green socks clause, which I've mentioned earlier, would, in my view, be the preferable route to follow. It doesn't mean that you can simply go around and dismiss people or retire them on a whim. There has to be processes followed. But where the benefit in going down the compulsory retirement route is that you do not have to provide those reasons. There are a couple of issues in relation to compulsory retirements in relation to age, which I'll cover later in this webinar. But insofar as performance and other related issues are concerned, you don't have to put a detailed set of grounds to that partner. You simply have your meeting, follow the procedures, at which point the retirement can take effect. Where it becomes more difficult is if you do not have such a provision in your partnership agreement. So you could have a partnership agreement which, for whatever reason, doesn't include a provision which allows a compulsory retirement without reason. In those circumstances, you'd be looking at expulsion. And an expulsion is very much a last resort. It can be very difficult, can be very contentious and time-consuming. So if you've reached that point, then it is always best and preferable, in my view, to see if there's some other way in which matters can be resolved or how that departure can be handled. And often that can involving mediation services with the LMC or other mediation services. But if you get to the point when you believe that will not work, then you have to go and consider expulsion. It's taking somebody's livelihood away. So it is a very serious matter, and you have to take it very seriously. Otherwise, there can be difficulties and problems which arise down the line. The process, again, it's a question of looking at your partnership agreement, making sure that you follow the processes which are set out in that. So it's following the letter of that partnership agreement. If you don't, that can cause difficulties and can invalidate the steps that are being taken. A standard partnership agreement will have a number of provisions regarding an expulsion. You may have a period of notice which has to be given. There may be special majorities of votes which have to be secured to ensure that the expulsion takes place. You can have rights of appeal within that, and you may have to provide reasons for the proposed expulsion before any meeting. The golden rule really is to act in good faith and to be fair in the approach that you take, and to follow the partnership agreement meticulously. If you don't follow the partnership agreement meticulously, as I will say later, then you can run into challenges, and indeed any expulsion may be invalid and could give rise to a claim by the partner concerned that you yourselves have so materially breached the partnership agreement that they can seek a dissolution of the partnership. One of the things that you need to give some thought to is whether the person should be entitled to have a fair hearing, whether or not they can answer the allegations which are made against them. And as I'll cover shortly, there are considerations which have to be taken into consideration as to whether you go down that route and whether you allow the person to make representations, either represented or otherwise. Now, let's assume that you have a matter where you believe that expulsion is appropriate, but you want to undertake a proper and a detailed investigation, or there are certain matters that you wish to clarify. There can, in certain partnership agreements, be provisions to suspend the partner concerned. Do not overlook this power and this ability. It can be very useful because it can allow you to remove a partner from the practice whilst that investigation is undertaken. In more serious cases, say there are, for example, clinical concerns over a particular partner, you can suspend that partner. So if you are approaching an expulsion, do not think that you have to go immediately to the expulsion. You can, if your partnership agreement allows you to, take steps to suspend that partner. But as with any expulsion and any compulsory retirement, you need to follow the procedures very carefully as you take those measures, because you are again suspending somebody from the practice, You will also have to give consideration in your partnership agreement as to how profits and drawings and pay should be dealt with during that period of suspension and how long that can be put in place for. But it's not to be overlooked. It can be very useful, and it's certainly something to consider when you've reached that stage where a potential expulsion is on the cards. Now, if you do move to an expulsion and you get it wrong, you can be challenged, and challenges can be difficult, they can be expensive, and they can end up in court. You are taking away, again, as I said, livelihood, people's identity as a partner in a medical practice. And if you fail to approach any expulsion or compulsory retirement in a fair and even manner, then you do run significant risks of that expulsion or retirement being challenged. If successfully challenged, and as I've mentioned briefly earlier, that can give rise to legal litigation. It can give rise to allegations that those partners who've taken that action have themselves breached the partnership agreement, so sufficiently seriously breached the partnership agreement that allows the other partner to make an application to the court to dissolve the whole practice and the partnership. If a partnership is dissolved, either by a court order or by some form of other dissolution, there are serious ramifications for the practice. You can lose your GMS contract or PMS contract. It can terminate your contracts with suppliers and with your employees. It can trigger all sorts of liabilities, and the partnership will effectively come to an end. In most circumstances, assets of the partnership would have to be sold. So getting it right is very important. If you do it properly, if you have grounds on an expulsion, and as long as you act in good faith in relation to a compulsory retirement, then hopefully that will stand as a valid retirement or expulsion. But what else can you do to try and avoid any sort of challenges? Well, in any partnership, one of the main duties is the duty of utmost good faith, and that extends to any approach to removing somebody from the partnership. You have to act in good faith. You have to be fair and reasonable in your approach. You have to make sure that all relevant matters are taken into consideration. And you shouldn't be rejecting any matters which are relevant by simply saying, we're not going to look at that, we don't care about that other issue. So you have to take into account the whole picture, consider the whole picture, and then you have to consider, once you have that whole picture, the decision that you intend to take. And there is some principles which the court may well apply if reviewing a decision to expel a partnership, called the Wensbury principles, which effectively mean that you take into account all relevant matters, you don't disregard relevant matters, and once you've done that analysis, that you reach a decision, a reasonable decision, that there's a reasonable rationale for that decision. It doesn't have to be the right decision, and obviously it will be perceived by the partner being expelled as often being unfair. But as long as a decision could have been taken reasonably, based on a full analysis of the evidence, then your decision to expel, if that is the decision you take, should be held as valid by the court. How do you prove you've acted fairly? How do you put that actually into practice when you're moving through the expulsion process? The most important thing, again, is to act in good faith, to be fair. You have to meticulously follow the provisions under the partnership agreement. They will be strictly interpreted by the court. So if you have to give a notice, if you have to give a time period for responding to any allegations that you're made, you must do that. You can't say that they don't apply to us, or they're not important, or it's also obvious that we can just expel and get rid of the person. When you enter into the partnership agreement, the words that you sign, and when you sign that deed of partnership, they are binding. They govern what you should be doing and how that partnership is operated. And that applies more importantly, almost more importantly, to expulsion when the stakes are raised in relation to the retirement or expulsion of a partner. Now, your decision will be, if it is reviewed, will have to be objectively justifiable. You'll have to show that there was a reasonable rationale for the decision you took. You need to avoid unguarded emails. I've seen cases in which WhatsApp groups have been set up, which are disclosable in any court proceedings, in which predetermination of the position has been taken, and quite clearly the partners had reached a decision and were just going through the motions and had very different reasons for expelling the partner than that which were being said or being put to them in a formal context. So unguarded emails, WhatsApp groups, all of those things, you need to think very carefully when you're talking with your fellow partners about a potential expulsion as to what you're putting in writing, and that is, or if it is viewed later by a judge in a court, that judge would think that is a reasonable email, a sensible email, and it is looking at the position fairly and objectively and is following the processes as the partners agreed when they entered into the partnership agreement. You need to keep accurate and proper records. You should have an audit trail. So if there are any challenges at some point in time, that you can have a series of documents which you can show how that decision was taken and how the factors were taken into consideration. It is, in my view, although there's no clear definitive guidance from the courts as to whether or not a partner should be given the opportunity to respond to allegations, there is no legal authority says you should, but in my view, it is sensible that you do that. And you should prepare a notice proposing or setting out the grounds. You should carefully prepare that, make sure it reads sensibly and properly. You should give the opportunity to review that to be given to the person who is the subject of those allegations. You should follow the notice provisions for the meeting, and you should think fairly and listen carefully during the course of that meeting to any representations which are being made. You do not have to take a decision at that particular time. You can do it later, subject to the terms of your partnership agreement. But if you then decide to go through with the expulsion, it is worth recording that the decision-making process that was taken and then setting out in a notice to the partner the reasons why you've concluded that an expulsion was appropriate in the circumstances and advising them of their expulsion. So if you do it properly and sensibly and fairly, you will find that the challenges to an expulsion or a compulsory retirement are going to be fairly limited. But don't think you can just make it up on the hoof, because that is inherently dangerous to do, and it in itself could be considered to be a breach of your duties to that partner to treat him fairly, in good faith, and to properly follow what the partnership agreement specified as to the routes and the processes to be followed. Now, there is a final point that needs to be taken into consideration as well, and this is the Equality Act. Now, a partner is not an employee. You can have salaried partners who are employees, and that's a separate topic. But if you are what I would loosely refer to as an owner partner of a partnership, you are not an employee. You do not have the majority of the employee rights that an employed person would have. There's no right of unfair dismissal. Where, however, there are protections for any partner and which apply to a partnership are some provisions under the Equality Act. Now, the Equality Act is an Act of Parliament that's been in the statute books for a number of years now, but its intention is to prevent and to provide remedies for those who've been discriminated against. The Act identifies what we call protected characteristics, and if there's any discrimination or expulsion or compulsory retirement based on any of those protected characteristics, that can lead into significant difficulties and challenges not just in the civil courts, but in the employment tribunals. Now, the protected characteristics are age, disability, gender reassignment, marriage or civil partnerships, pregnancy and maternity, race, religion, sex or sexual orientation. And therefore, if there's any concern or suspicion that the expulsion is motivated by those protected characteristics, then you may face challenges in an employment tribunal. And that employment tribunal has a number of powers. It can order compensation, and that can be significant loss of earnings and for injury to feelings. It can make a declaration as to the rights between the parties, and it can give guidance and or directions to the partnership as to how it should approach issues of discrimination. So if you are moving towards a retirement or expulsion, and there are issues which arise in relation to the particular partner, they may not be the reason that you're thinking of expelling that person, but they certainly do need to be factored in. Because if there is any suggestion or concern that your decision is motivated by any element of discrimination against any of those protected characteristics or people with those protected characteristics, then you may find yourself in a very, very difficult situation with significant damages to be paid and legal costs to be faced. So if you are moving towards an expulsion and those issues arise, it is, in my view, sensible to seek legal advice at that stage, just to ensure that the full extent of that legislation is understood. A couple of common areas will often arise. One is a compulsory retirement on the basis of age. A number of partnership agreements require people to retire at a particular age. Now, if you seek to retire somebody, there can be a provision in your agreement that says you've got to retire at 65. That itself could be considered to be discriminatory. There are certain steps that you can take to prevent that giving rise to any challenges. And if the legitimate aim of the business and that age requirement, or the requirement to retire at a particular age, is proportionate means of securing a legitimate aim of the business, it can be defended. But as I said, it's a very complicated and difficult area, and one which shouldn't be navigated simply alone, and often legal advice is required in those circumstances. So I think I'm approaching just under half an hour at the moment. It's been a sort of rather swift trip through compulsory retirement and expulsion and leaving a partnership. It's my final sort of comments really are this: never take any decision lightly. This is not a matter where you can suddenly decide on a Monday that you're fed up with somebody and try and get rid of them on a Tuesday. You have to think it through. There are ramifications for the partnership on losing any partners. There are potential issues for your staff who may find one of the partners being removed to be popular, or they may like them, and they might find it's a very unfair decision. So you need to think it through very carefully. And if you are deciding to take that route, think if there's any other ways in which any problems can be resolved without having to go down the route of the formality of the partnership agreement. Majority of cases I get involved in, decisions have been taken, challenges have been made, and we're trying to unravel problems which have been caused. The better cases for me are when I'm consulted at an early stage and we can give some consideration as to what routes are available to those partners who wish to retire or expel another partner. And that can be by an agreement, by various other methods which we can employ, which avoid the contentious side that comes into play when you follow a very formal procedure. Think very carefully about what you need to do. Think of the reasons you're doing it. And if you decide to move forward, make sure, number one, you act in good faith and you're fair. And that secondly, you follow very, very carefully the provisions of the partnership agreement, which you have all agreed to abide by and which govern the partnership. I hope none of you ever have to go down this route. I hope most of you will always be dealing with voluntary retirements after long and happy careers within partnerships. But again, if there are problems, make sure your partnership agreement is up to date. Make sure that it properly covers the type of breaches or problems that can arise and matters for which you require or think expulsion is appropriate, and make sure the procedures work for your particular partnership. It's worth looking at your partnership agreement, both as a partner, but also as a partnership, to ensure that it's fit for purpose and ready to be relied upon if unfortunately circumstances arise which mean that becomes necessary. Now I'm going to finish up and round up on or wrap up on the webinar on my talking, I know that there will be questions. I get, through the wonders of technology, the ability to read some of the questions. I won't be able to deal with all of them, but I will look at some of those questions, and I'll do my best to answer any particular points or issues or concerns that you have. I should hasten to add, I can't give specific advice. I can give general observations, and I can't comment on any individuals or mention any names or other matters for protection reasons, but happy to answer any general questions or any thoughts that you may have as to some of the issues that we've talked about or I've talked about this afternoon. I think the first question here is a partner has been reported to the GMC with a false allegation, the purpose of which is removed from the partnership. How can you deal with that? Now, I have come across this on a couple of occasions where relationships between partners become so difficult that they, should we say, put forward allegations which try to undermine the professional position of the fellow partner. The most important thing, I think, for a partner faced with those allegations is to ensure that they deal properly and effectively with any GMC or other regulatory inquiry. If those allegations are fallacious and have no foundation, then hopefully with the support of your medical defence union, those can be resisted and your name can be cleared, which again removes the ability to rely upon any findings of the GMC to remove you from the partnership. It is a very difficult situation, however, and if false allegations are made, it does go to the root of the partnership. Look after yourself in those circumstances, and if any partner is considering making false allegations, they themselves, if they are shown to be false, can themselves face GMC issues at a later date. If you've been removed unlawfully and unfairly as a matter of civil law, then you can seek a dissolution from the court of the partnership. And if you believe that you've suffered financially as a consequence of fallacious allegations, you've been deprived of the profit that you would have made and earnings, reputation, there are cases which allow damage to be recovered in those circumstances. The next question is, could you enlighten us about the law with respect to age discrimination? It's difficult really to say anything more than in general terms. It is unlawful to discriminate on the basis of one's age. However, if you are in a particular business which requires younger people to undertake the business and to operate the business, and there are legitimate business and commercial reasons why an older person would not necessarily be able to discharge their duties and responsibilities to secure that legitimate aim, you can defend an allegation that you've acted in a discriminatory manner towards somebody who's older. You often see in partnership agreements which require partners to retire at 65. Well, you might actually want that. Some partners might not want to go on past 65. But if you are challenged on that and a partner says, well, actually, I know what the partnership agreement says, but it's discriminatory, I want to stay on for another 10 or so years, then you may face a challenge. And what you would need to do in those circumstances is to demonstrate why that what is a prima facie discriminatory provision is reasonable and is a proportionate means of securing the commercial future of your business. So, for example, if you wanted to expand and that party was refusing to agree, or needed to move offices and that party didn't want to go elsewhere, or there was some other reason why his age would not be appropriate or her age would not be appropriate, you have to have a legitimate commercial and proportionate means of ensuring that legitimate commercial purpose. It's very difficult. If you come across this situation and you're facing suggesting you've discriminated against somebody because of their age, because of your requirement for them to retire, you do need to be seeking legal advice, because they are quite nuanced, and each one is a subjective analysis of your business and its legitimate commercial aims. The next question was slightly off point, but I'll deal with it anyway. As a salary fixed partner, that mixes a number of terminologies. You have in a partnership agreement what I would call the property owning partners in a general partnership. Those are those who own a share of the business. So 4 partners, each owns 25% of that business. Each is entitled to a 25% share of the profit of that practice. Now, what if you don't want to make somebody or allow somebody to join the practice in that capacity? It would mean, if you wanted to admit a 5th partner, reducing potentially your profit, reducing your share of the assets of the partnership. But you still wanted that person to come on board, or alternatively, that person themselves didn't want to face the risks that may be involved in assuming liabilities of the partnership. There are 2 options in those circumstances. First of which is a fixed partner, and a fixed share partner, as one would call it, is somebody who you identify as somebody you want to be a partner, but you limit their profit, you limit their investment in the business. The quid pro quo for that is to ensure those property owning partners properly guarantee and provide indemnities for that fixed share partner for any liabilities of the partnership. As I mentioned on the previous webinar some months ago now, don't forget that a partnership has unlimited liability. What that means is that if a party claims against the partnership, the partnership assets should be used first to pay that liability. After that, if there's not enough money, each of the partners has to contribute towards those liabilities. A fixed share would have a limited contribution towards those liabilities, and to the extent that fixed partner was pursued by a third party, would be able to look to the other parties to cover him or her for that additional liability. Now, that's a sort of fixed partner. A salaried partner is and remains normally an employee of practice. They're held out to the outside world as a partner. They can bind the partnership, but they do retain those employment rights and are protected under the employment legislation, which, in addition to the Equality Act, also covers unfair dismissal and redundancy and all those other employment law matters that arise. Yes, there's another question. Again, this is quite sort of heavy and fact specific. But what about counter allegations, whistleblowing, NH fraud coming from the expelled partner, criticism of litigation against the practice from a third party showing significant substandard performance? Now, these are very, very difficult cases, and clearly the relationships are becoming very difficult. The first of most obvious point is whether there's any substance in those allegations, or whether anything that should be done to protect the reputation of the partnership. But if a partner is making false allegations or allegations which are done in bad faith, they themselves can give rise to an expulsion from the practice. You need to have give very careful consideration to it, because what you don't want to do is to expel somebody for whistleblowing, which in certain circumstances is protected. You don't want to expel somebody for raising legitimate concerns, and your efforts would need to be properly spent, I would have thought, on resolving those difficulties rather than concentrating on the partner who brought these matters to the attention of the appropriate authorities. But if those allegations are concocted or inaccurate or spun incorrectly, number one is always look after the partnership. Then you will need to consider objectively whether those allegations that have been made are such that they give rise to either a retirement on a compulsory basis, where you may not have to give reasons, or alternatively, whether it gives rise to an expulsion. But they are very, very difficult situations, those. You are, in any partnership dispute, you are, and I repeated this a few times, you are taking away somebody's livelihood. Often you're also taking away their identity. They may have been a GP for many years, that could be their life. And often you will find when people are scared and frightened over their future and things are being taken from them, that they will make allegations which perhaps in other times they wouldn't have made or they might regret at some point. You've got to hold firm, remain objective, deal with it properly and appropriately with the benefit of legal advice if required. And then once you've dealt with that, give some objective consideration as to whether or not such is the fallacious nature or such is the nature of those allegations that the wider interests of the partnership have been put at risk, and as a consequence they're so serious they go to the root of that person remaining in the partnership, and as such whether you can invoke the the expulsion or the provisions which allow for the compulsory retirement. Yeah, this is a topic that I didn't cover too much, but voluntary retirement. I've been asked to say a little about the impact of voluntary retirement where there is no partnership agreement. If you have no partnership agreement, you have a partnership at will. At its very simplest, a partnership is an agreement between two or more people to engage in business with a view to making profit. It comes from, it's one of the oldest legal relationships that exists, and I think I mentioned in my previous webinar for those that were in attendance that all it takes is a shake of the hands. You know, it's about taking sheep to market. You know, I'll lend you my cart, you've got the sheep, let's do one trip to market and we'll divide up the profit afterwards. What you then have to look at is the 1890 Partnership Act, which came in to try and regularise some of the disputes which had arisen and which had troubled the courts before that date. If you don't have a partnership agreement, your default position is the Partnership Act 1890, and you will be in a partnership at will. And what the Partnership Act 1890 says is that if you want to leave a partnership, you have to dissolve it. And all you need to do is to give notice of dissolution. You can send a letter on a Monday morning saying, I dissolve the partnership, and that's the end of the business. You don't have to wind it up. You have to go through that process. It terminates contracts. It can do all sorts of other things. So if there's no partnership agreement, there is no voluntary retirement. The only option you have is to dissolve, which gets you out of the partnership, but in a very expensive and potentially very dangerous way. There's no substitute for a partnership agreement. If you sit down with your partners, if you are in a partnership at will at the moment, I can only advise you to go and speak to some lawyers or to get yourself a partnership agreement to protect you from the effects of a partnership at will, which is a very dangerous place to be. If when you're preparing that partnership agreement, give some thought to the voluntary retirement provisions. The only way you can retire from a partnership voluntarily is in accordance with the partnership agreement. If your fellow partners don't want you to retire, or there's no provision in your partnership agreement to do that, you can't retire. You have to find another way of getting out of it. So make sure those retirement provisions are fit for the purpose. If, for example, however, say it requires you to give 12 months notice, if you say there's a pressing reason why you need to retire earlier, then there's no substitute for then having that discussion with your fellow partners. Whilst your partnership agreement will say what you should do, there's nothing in law which prevents or prohibits a different arrangement or waiving of certain of those provisions. So the impact of a voluntary retirement where there is no partnership agreement, well, it's sort of mixing terms really. If you have no partnership agreement, you can pretty much only retire by a dissolution. If you have a partnership agreement, make sure the voluntary retirement provisions are fit for purpose, suit both the partnership and the individual. That means timing things like accounts dates, that retirements can only fall on the accounts dates to save separate accounts being prepared. Think about restrictive covenants to protect the business, those sorts of issues you need to be thinking about. Connected question, do the same rules apply for expulsion when acting in a partnership at will? No, you dissolve in a partnership at will. The Partnership Act 1890 has a specific provision which says that unless there is an express agreement, there is no general power to expel a partner from a partnership. It defaults back to a position where you then have to dissolve the partnership. So if you want to have a provision which allows for expulsion, You have to have a partnership agreement or an express agreement which allows that to happen. Without that, you're stuck on the Partnership Act 1890, which 132 years old, probably not exactly the most modern piece of legislation, and was designed really for a very different environment than we find ourselves now in the year 2022. With disability, how is this recognised? Occupational health assessment. Well, if somebody is saying that they have a protected disability, then you can have provisions under your partnership agreement, which normally touch on the sort of absence and being away from the partnership. And you should think carefully when you're preparing your partnership agreement as to methods by which those disability, because a disability has to actually affect your ability to do the job. And if you have questions over whether or not there is a disability, whether it does in fact fall within the Equality Act, it's always a wise precaution to have something in your partnership agreement which allows some sort of independent verification of that process. It's very, if a partner refuses a health assessment, but they've entered into a partnership agreement where they've agreed as part of that partnership agreement to take part in that, that's the way they've agreed that the partnership will operate, that itself could be considered to be a breach of the partnership agreement. Of course, you'd still need to be quite careful in relation to discrimination, and you probably need to take legal advice in those circumstances. But certainly a partner who is claiming they have a disability, but who is not prepared to have that verified by an independent person, I think is running some risks on the basis that if they genuinely felt there was a disability, they would have no issue in submitting to an occupational assessment. It's quite a long question, which is slightly less legal and more as to how you deal with people, which effectively says there's an unspoken recurring theme in relation to compulsory retirements, where there's an imbalance of power between the expelling partners, which is tantamount to bullying and coercion of meeker individuals, too afraid to speak up and ensure fair play towards the individuals. Any comments on how a partnership can avoid a toxic bullying leading partnership practice the wrong pathway? It is very difficult. It's a very difficult situation, and with in most walks of life, but I've seen this in law firms as well, where they're almost like a small group of partners who believe their decisions are final. You can have mediation provisions in partnership agreements. You can have, and I've seen it's becoming more common in partnership agreements, for both an expulsion and compulsory retirements, for counter notices to be served and for the parties to go to an independent mediator to resolve those matters. That's where an independent third party can come in and try and resolve those difficulties and try and address some of the reasons why they've got to that stage. I rather suspect there's no swift and easy answer to what are effectively personality issues which can arise and which give rise to a toxic culture. I think as an individual partner, you've got to either consider whether that's somewhere you'd want to remain in any event. Is it something worth fighting for? Or whether you think you should go and find a partnership that actually welcomes and values your input, and rather leave them to themselves. But it is a very difficult and often insoluble problem, often only dealt with by one or other of the partners leaving or retiring, or you yourself, if you are the victim of that, to remove yourself from the practice. This again is slightly off point, but the remaining partners still haven't bought out my share of the building after the partnership agreement says that they should have done so and should have been done within 12 months of my retirement. And from what I can see, a number of gentle reminders and persuasions have been attempted. At the end of the day, a partnership agreement is a contractual relationship. If you have entered into a partnership agreement, there's a follow-up to a retirement or an expulsion, and that is the provisions in any usefully or properly prepared partnership agreement which deal with how the outgoing partner is dealt with. Now, when you've tied a knot of partnership, you've got to undo it. The expulsion is the start point, but then there are financial obligations and commitments. There's handing back office material, there's handing back office equipment, there's valuations of premises, there's valuations of the assets of the practice. And normally the way that you do it is to say, right, well, okay, the retirement takes effect or the expulsion takes effect on a particular date. You draw the line to that date, you work out the capital account, the current account, and that is a sum to be paid over a period of time, which after a period of time will normally carry interest if not paid. Now, any big chunk of cash going out of a business needs to be handled very carefully. So often you'll see this paid over a period of time, and 12 months is not unusual. But if one party does not, or the continuing partners do not meet that obligation, then there are interest provisions which can be invoked. And if needs be, the matter can be referred to a court. They've agreed as part of that partnership agreement to pay you within 12 months. If the figure has been set by the succession or the retirement accounts, and that number is known and agreed, then there's no reason that you should not be raising the ante and pointing out to those partners that unless payment is made fairly shortly, that you should be taking the matter to court and you should be securing an order from the court that they meet the obligations to make payment to you. It's unfortunate. You've got to also, like any litigation, I don't just do litigation with GPs, but I do chase money and it's part of my job. But is it can't pay or won't pay? And sometimes if they haven't got the money, they simply can't afford it. You might want to think with them how best that can be dealt with, over payment over a period of time with interest. If it simply can't pay or they can't be bothered, then you need to escalate matters, in my view. Yeah, decision making. If there isn't a majority vote, but an even 50-50 split, how to move on? But again, it's difficult because these issues where people are being threatened with expulsion inevitably cause problems within the atmosphere of the office. Normally, in any expulsion, you will have to have unanimity. That doesn't include the vote of the partner who's being potentially expelled, but you do have to have unanimity. If you can, in your partnership agreement, have different splits of votes, but a 50-50 split where, say, for example, you've got 5 partners, 2 say yes, 2 say no, well, that doesn't carry. That's not effectively a valid vote. It doesn't pass the hurdle that the partners have agreed. How to move on, that's a combination of whether or not you wish to remain in that partnership, whether you yourself would wish to retire in those circumstances, or alternatively, whether you invoke some sort of method of resolving those problems or those deadlocks which have arisen. It is a difficult situation because and you do find, coming back to one of the earlier questions, you can often find cliques within a partnership where some people are very loyal and supportive of one partner, others take a very different view. Their loyalty won't allow them to remove a partner, even though everything in their fibre says that that partner should leave. You've got to think in those circumstances, if you can't carry that vote, if it's going to remain in that deadlock or stalemate, whether or not there are other methods to bring that partnership to a conclusion, or whether you yourself wish to leave that partnership. It's very difficult. It's like neighbour disputes, which I haven't done for many years. But it's when the neighbour's causing problems. Why should I move? Why shouldn't they move? Well, whose pride is going to go first? Where it is a 50-50 split, you need to just try and move on with it as best you can. Find a method of mediating between the parties or resolving those issues. And if not, then you need to give some consideration to the whole future of the partnership. I've probably just got time for one more, and I'm trying to find one which I haven't probably answered or dealt with in full or in part. think there's one question which slightly off point, but I think is worthwhile commenting on. What advice would you give to partners where one partner refuses to engage in the development of a partnership agreement? I think with a partnership is a group of individuals. I've been in a partnership with 160 partners. I've also been in rather smaller partnerships. An unwilling or a reluctant participant is always a difficult situation. The last thing you want to do is to start looking at what your legal rights are. I say that as a solicitor who's dealt with in enforcing legal rights over many years. If you can try and sell the development of a partnership agreement, give valid, coherent reasons why it is important for the partnership to have a partnership agreement which is fit for purposes at the date it's signed, but all has the ability to be flexible going forward, then you need to try and win that battle of hearts and minds in that way. If, of course, that partner refuses and you've got a partnership agreement which is not fit for purpose and which locks you into what might have been appropriate for 10 or 15 years previously, again, I keep saying this, but you've got to think very carefully as to whether there are routes available to you within your partnership agreement or otherwise under which you can, once you've exhausted the carrot, as they say, whether there's a stick there to try and encourage that person to try and come to the table and engage in that particular process. It is difficult. It's an individual decision. You've got to try and understand what the fears are. Most people have reasons why, then sometimes don't articulate them, which can be very difficult for people to try and identify. But you need to sit down and have a proper conversation and to try and understand exactly the reasons for that and see whether you can hopefully assist in dealing or assuaging any concerns or fears that they've got. Now, I'm running to 2 minutes to 2. I think I've slightly run over by about 10 minutes. I'm sorry I've not been able to answer all the questions. You are able to contact me afterwards. Email addresses are available if you want to follow up on any further questions. And without further ado, thank you very much for taking time out of what are very busy schedules. I hope you found today interesting and useful. And at this stage, hopefully mastering the technology, I'll pass back to BMA Law, who will exit me, as it were, not, no pun intended, from the process today.